Muito boa noite a todos. Good evening, everyone. It's my own extreme pleasure to receive my friend Blazej tonight. We've been discussing this event for some opportunities. The idea came up when we met and we were discussing recently. It was my wish to have a class in Brazil, an event like this to discuss a topic that no one in Brazil talks about, which is the bilateral investment treaties and all sorts of similar treaties. So it's a great honor to put this in place. Thank you very much, Blazej, to having accepted the invitation to come to Brazil. It's an honor for IBDT to receive you here. Blazej Kuzniacki, if I say it right, unpronounceable name, is a great expert in international tax law. For those of you who know him or never met him before, he publishes a lot. He's a great researcher. I met him a few years ago, when we came across in different countries, and I've always been following his work. It's really impressive in many different areas. He's going to have the opportunity to show us a bit of that. And talking about bit, Brazil very often signs bilateral investment treaties with other nations, and unfortunately, our mentality, the Congress, the Brazilian Congress mentality has been blocking these treaties. So not many treaties were approved. Only 3 treaties, BITs with Mexico and Angola. And recently Brazil started reshaping the BITs and wrapping them up together with cooperation and investment facilitation agreement. Those are precisely the ones we recently signed with the United Arab Emirates and Singapore. So we believe the United Arab Emirates Cooperation and Facilitation of Investment Treaty was ratified by the Brazilian Congress, and we do hope that the Singapore Treaty will also follow suit. But anyway, this topic is very important for multinationals in general, especially also Brazilian multinationals that invest abroad in countries that have a not so solid system, juridical system or tax system, and the bilateral investment treaty is a way to attract greater protection to your investment. But unfortunately, in Brazil, no one publishes. Here at IBDT, we never held a class about this topic, and I want, with this opportunity, with this event today, foster, incentivize people to dedicate their time and efforts to understand this better, publish, to create a greater awareness of this in the Brazilian international tax law landscape. But it's not my role to be speaking. Romero Tavares is going to join us in a few minutes. He is also going to, instigate Blazej with questions, and comments. They both work together for PwC. I hope you all enjoyed this opportunity. Thank you again, my friend, for making your time to come to Brazil and give us this lecture.
Obrigado. It's a pleasure, Victor, to be here again for the 5th time in my life. So to start, just try to see if first slides is visible. So how it works? Okay, perfect. So as you see, the title in itself is provocative because it includes the word abuse, and abuse in almost every context has a lot of emotional workload. No one wants to admit that it's abusive, especially as state nowadays. So the focus of the presentation would be to take you in a journey through, I would say, not very well discovered or examined lands by tax experts, which is investment treaties protection. But the reason why it fits well to discuss whether states use or abuse fiscal power or tax power is that investment treaties include standards of protection. And if those standards or one of them is violated, you may consider that the use of fiscal power was so incorrect, so improper, that it is no longer a use of tax power, it's abuse. And we will go also through cases that will exemplify it beyond the theoretical framework. So before I start, I actually want to give you the book I wrote. It's my habilitation on beneficial owner, and not on investment treaties yet, although maybe something will be produced in a few years. But I hope it will be, you will be beneficial of knowledge in that book. Your students were a few days ago, and now, yeah, I hope that you will like it. So
it's great to incorporate that to our library, so it's available to anyone interested. It's a great work on beneficial ownership. I would say the best and most updated work on a hard topic. Oh yeah, exactly. And you are the Marisa laureado Mitchell B. Carroll Prize, exactly.
Yeah. Okay, so even before I start the core of subject matter, I want to refer you to the new newsletter that I kicked off actually just the day before my flight to São Paulo. Tax in international context on my LinkedIn profile. If you lose something today, you may find in this newsletter in the articles. The first article is about the new Article 25 of the UN Model Tax Convention, which aims to override investment treaty protection mechanism, which is investment treaty arbitration or investor-state dispute settlement. So that's what has been decided at the level of the UN. And although this was kicked off just less than a week ago, it has almost 3,000 subscribers. So I'm very happy that it grows. And at the beginning, again, instead of in the end, reference to publications that I wrote on the topic. Today, very coincidentally, I got email from Columbia University in New York that this short part is just 2-pager, and which is about how best to reconcile Pillar 2 with investment treaties, has been read by nearly 5,000 people in less than a month, which is a lot, I've been told. So it shows that the topic is of relevance for many stakeholders. Another recent paper with Professor Rowan Avionach, it's still a draft, but more than 600 people already downloaded from SSRN, which is also a great success, and we will discuss it at an event in Toronto with many other brilliant scholars like Cili Dagan, Kik Elif, Jay Lee, Angelo Nikolakakis, etc. So we will have entire panel about what we can observe now, like in US, powerful states decide to focus more on the rule of power rather than the rule of law, and when, if that stops. And finally, references to my works with my dear friend Stefan Wegel, who introduced me to this topic in 2020. I was immediately hooked, and I could not stop really examining this area and going deeper and broader and further. So those articles here are published in a journal which is not well known by tax scholars. It's BRI journal. BRI stands from BRICS countries, led by China. So you see that the one on the left is precisely about dispute resolution, cross-border dispute resolution. And then we make a point with Steph, which was catch up by IFA Global last year in Cape Town, that maybe MAP and treaty arbitration are not the most efficient ways to deal with cross-border disputes, apart from the fact that they are mainly about transfer pricing or recognition of a permanent establishment. But what could benefit states, especially developing states, is a body of experts, the opinions of which would not be legally binding for states. Such states are always worried about sovereignty, but by means of the persuasive value and the authority behind them, authority of personas behind them, such opinions could shape cross-border dispute resolution case law. And the other article from June this year is about tax policy and investment treaty protection, a way to reduce risk of investments, which is partly a response to the call of the president of China, which in 2022 asked the ministries to find a way to reduce the risk of foreign investment in China, so inbound in China, and foreign investment of Chinese MNEs abroad. And we put a point with Steph that one of the unexplored ways is to look at the interplay between investment treaties and taxation, something which was, I think, deliberately not overlooked, but ignored, you may say, it's not too strong words, by the OECD, but we will come back to it. So that's the background, the outline. First, I will try to introduce you to the topic, assuming that you are not experts in the topic. Then we will examine selected treaty arbitration cases, a case against Poland, Hortel, against India, Car Energy, and against South Korea, Lone Star case. And finally, I will refer to global minimum taxation and how Pillar 2 may be a troublemaker for investment treaty protection. So, if you have, can you hear? No. Should be. Now it's fine. Yes, now it's fine. If you have questions, you can interrupt me on ongoing basis, and we may have debate on ongoing basis. Although also, if you have time in the end, we may have more like a Q&A session. But including, of course, you, Romero, Victor, and anyone in the room, feel free to interrupt me, and I enhance you to do so. So, introduction. What are investment treaties? The broadest categories is called international investment agreements, and they consist bilateral investment treaties, as mentioned by Victor, but not only bilateral, they are also multilateral investment treaties. And the most important is Energy Charter Treaty. Actually, the most investment treaty arbitration cases are under Energy Charter Treaty, and the reason for that is that energy sector is most prone to abuse of state power in general, including power to tax. Investment treaties have very broad protection standards. The broadest is the so-called fair and equitable treatment, FET in abbreviation, which embodies many substandards, and is enough that one substandard or one principle, which is covered by fair and equitable treatment, for example, principle of non-discrimination or principle of legal certainty, is violated by taxation, by tax authorities or tax legislators or judiciary power, then it is considered that a country violated the investment treaty. Another broad standard, national treatment, it's broader than under tax treaties, typically, because it prohibits any type of discrimination, both de jure and de facto, direct and indirect, covert and overt. And we will discuss a bit more when I will refer to Mexican cases that were raised by the US investors. Most favored nation clause, you may recall that there are not that many cases under tax treaties, partly because MFN is not part of the UN or the OECD Model Tax Convention. Nevertheless, there are more than 500 treaties around the world which include MFN clauses. Think about G7 political agreement to agree on something, which is side by side a US minimum tax regime and the OECD Pillar 2 regime. MFN basically means that if you provide special treatment to companies from one country, you must provide such treatment to every company in the world. This is how also WTO works and international trade regime. And I think that Brazil is part of WTO, right? China also joined, I think, in early 2000. So it will be interesting when member states of inclusive framework will discuss not only politically difficult elements of the deal, but also legal, like international trade and investment treaties. Investment treaties contain very broad definitions of investor and investment, to which we will come back, but it helps to shop treaties even easier than tax treaties. So treaty shopping under investment treaties is much easier than under tax treaties. And finally, umbrella clause is a separate standard which is activated whenever a state enters into an agreement with an investor. Think about extractives. Very often, when a foreign investor needs to invest billions of dollars at the beginning to put in place infrastructure to exploit oil or gas or in respect of mining, countries offer agreements with stabilization clauses. And part of stabilization clause often refers to certain tax treatment, which will not be subject to changes for the lifespan of the investment. And energy sector investments sometimes last for 20 to 40 years before they enter the stage of commercialization. So there are cases.
If I may contribute, that's not very common in Brazil. We've never done that. I don't remember. But in Latin America in general, South America, Chile, Peru, Colombia, many South American countries, they provide stabilization clauses to investors in the mining sector or energy sector. And what it means is that they freeze the tax law of the time of the investment. And that tax law keeps frozen for that particular taxpayer, for that particular investor, for 20 years, 30 years. And sometimes, or all the time, tax law changes, right? And then there comes, this interest of the country to apply the new law to the investor, presumably protected by the investment treaty, right? And then that's when the conflicts may arise.
Exactly.
As an example.
Exactly, perfect. Thank you, Victor. And what is the purpose of all of that? The purpose is to promote cross-border investments by providing foreign investors unprecedented level of far-reaching legal protection through a special dispute resolution mechanism, which is taken outside the jurisdiction in question, the jurisdiction that hosts investment. And it's called international investment treaty arbitration or investor-state dispute settlement. Without that tool, the example of Brazilian investment treaties, the treaties do not have a legal tool to enforce them. This table is a juxtaposition of how works ICDS versus other dispute resolution methods, be it domestic litigation, mutual agreement procedures, arbitration under double tax treaties, arbitration under EU directive, and OECD convention regarding arbitration of transfer pricing cases. So the first difference, I'm explaining this to just tell you what is the whole fuss about. Why United Nations decided to change Article 25 recently in March 2025. Why majority of UN countries didn't like and didn't want to have arbitration under investment treaties in respect to tax-related cases. Okay, so first of all, when you have a dispute with tax authority, before the dispute enters the stage of court, there is no equal powers. Tax authorities may want a lot from you, but you can do very little from tax authorities, right? So there is no equality in arms. In arbitration, under treaties, investment treaties, there is equality of arms from day one, because in a way it's a hybrid of international public law, which is embedded into the flexibility of civil procedure. If you want to find the best domestic equivalent, it's like Brazilian civil procedure, okay? But you have a way more power than in the civil procedure when you decide to have a case against Brazil under Brazilian civil law. And even if you think about Brazilian litigation, you cannot appoint one of the judges if there are 3 judges. In arbitration, you can appoint one of 3 arbitrators typically. The second arbitrator is appointed by a state, and the third one, the president, is decided by the 2 arbitrators. Okay. Also, in domestic settings, an opinion of an expert, for example, Van Weigel or Philip Baker, of Judith Friedman or Daniel Rosenblum. It's just private opinion. To be brutal, judges may say, who cares? Don't bother me. But under investment treaty arbitration, if they are appointed as experts, they are appointed by the tribunal. They are paid by the party, but they are appointed by the tribunal. So they need to serve to the tribunal according to the rules, and their expert reports are considered to be evidence. So much stronger position in investment treaty arbitration than domestic litigation. Also, domestic litigation arises from a set of rules. And you cannot change between different legislation. You have one legislation for procedure, and that's it. Under investment treaty arbitration, you can choose from many different procedures depending on the arbitration clause, but you can go as far as to look into Swiss arbitration procedure, Dutch arbitration procedure, French, Hong Kongian, Singaporean, UK, and prepare for the client strategy, arbitration strategy, which procedure will be most beneficial when you think about different scenarios, good and bad. You can't do that under domestic litigation. Also, think about judges. How many countries in the world have for sure impartial judges, impartial judgments? And in how many countries judges cannot, without risking their life and life of their families, decide high-stake cases against states? So the question about neutral forum. Is a court always neutral? For investment treaty arbitration, arbitrators are composed by two parties, and then they decide about president. If they cannot decide, then they ask the authority to decide, like Secretary General of Permanent Court of Arbitration in The Hague, or a judge of the ICJ, etc., etc. Another difference is that when Supreme Court in Brazil decides a case, it is not subject to review because it's the case of the court of the last instance. Apart from some extreme cases, if you prove, for example, that judge was bribed, so a crime was committed. So now think about cases like Lonstan versus Korea that I will discuss with you, or Stati versus Kazakhstan, that tax cases have been already decided by Supreme Courts, but an investor decided to arbitrate. There was no prohibition to arbitrate, even if the case is decided by the Supreme Court. However, from the perspective of the strategy, you need to bear in mind that if domestic court decides a case, unless there is denial of justice, some violation of procedure, the lack of impartiality, arbitrators will pay a lot of attention to domestic case law. Because domestic case law across the world in different countries is one of the sources that you can find evidence of opinio juris and the practice of states. Because practice of states manifests in three powers of states: legislative, executive, and judiciary. So judges as well, not only executive. For us, tax law, when we think about tax power, we mainly think about tax authorities. But tax power may be also used or abused by legislator. When there is a new legislation, single out only one entity, which is troublemaker for the state, and they are not happy with the CEO. And we will talk about such cases. And finally, the decision, the judgment of the first or the second instance, not the last instance, are always subject to appeal, are subject to review. That's not the case for arbitration awards, apart from very few situations. So it's difficult to change the outcome of arbitral award. A way more, not impossible, but a way more difficult than domestic judgment. And what if a country doesn't want to pay award, doesn't want to pay compensation? Then, if that country has assets that are not used for public purposes, and the assets are located in a territory of one of more than 150 countries, parties to ICSID convention, then you as an investor can ask for the court order from that country to freeze the assets and liquidate them. For example, India was not happy to pay to Card Energy award for more than $1 billion. So the US District Court in New York was asked to freeze the assets of the Indian islands Indian Airways. The same for Spain, which didn't want to pay award. The Cervantes Center in London was almost freezed and liquidated. So then the state wants to protect that presence. Okay, so
just a quick clarification here, Blazej. So taking that example, we litigate in the country, go to the highest court, the last decision is unfavorable. The company pays the tax infraction notice, then goes through arbitration, and the final result of arbitration is favorable to the taxpayer, then the taxpayer requires an indemnification, right? That requires a
compensation. There are special rules about that. What happens if a state commits an international wrongful act? RCVA rules, the rules that codify customary international law for committing an international wrongful act. Violation of an international treaty, be it tax treaty or investment treaty, constitutes an internationally wrongful act. Every state can always defend itself by the public policy reasons. So maybe some more important value protected under customary international law, like peace, justice, public health, than investment treaty, of course, but it must be proven, and the bar is high. And there are different types of compensation. Restitution, if possible. If restitution is impossible because it was destroyed completely, then you look into monetary compensation. But like in Carroll versus India, there were like different steps in taxes. For example, when you paid €1 billion tax, although you should, because it was violation of investment treaty, then state will pay you that. You will seek to receive back the money, but also cost of arbitration, also interest. There may be many factors taken into account, and this is domain of the so-called quantum experts. And they typically clash in their evaluation. The quantum expert of states will say 500 is enough. The quantum expert of investor will say 2 million is not enough, for example. This is how econometrics works, I believe. This map shows you red parts, the biggest decline in impartiality of judges according to Judicial Independence Index 2017-2021. You see that Poland has been singled out because we suffered from one of the most drastic down in impartiality due to the previous government and pressure put on judges. Now it's no longer the case, although the right side was outspoken about to be sure that the judges will do the right job, which means that judges will do what his party be done. So you have the more blue, like dark blue, Canada, Finland, means that impartiality is very high. Okay. So how investment treaty arbitration works? Of course, there must be an investor who has a claim under investment treaty. So there must be an investment treaty between the state of the investor, individual or a company, and the state that hosts investment, right? But by contrast to tax treaties, it may happen that you have several companies in the chain, and only one of the companies in the chain of ownership or control comes from a state that has the treaty with the state of the final investment. And that would be enough to have protection. And this protection, this arbitration may be initiated and sponsored by the ultimate company, which has not treaty with the country hosting the investment. Investment treaty arbitration is a powerful tool. Why? Because depending on the statistics, not all cases are publicly available, but significant percentage of all cases are settled. So in many cases, when a state realizes that there is an investor using that powerful tool against what state did, state do not want to go into arbitration. They sit, they discuss, and they settle. We don't know how, but they settle. How to bring the investment treaty claim? There are similarities, but also differences to tax treaties. In tax treaties, you first look into the personal scope. So is there a resident of their contracting states? Here you look if there is an investor, but the definition of investor is really broad, usually being a company established in accordance with the law of a state is enough. Then in tax treaties, you look into the tax. Is that tax covered by the treaty? Like big debate, is DST a tax covered by a treaty? Is an income tax significantly similar to income tax? Here, definition of investment is typically, in the vast majority of investment treaties, very broad. An investment is an investment in any kind of assets, any kind of assets. So shares in a foreign company is enough to say that's investment. Also, typically, investment treaties do not qualify investments as being only direct investment. It can be indirect investment. Investment realized through many entities in the chain. Some treaties, especially new one, will have qualifications for investor or investment. Something similar to principal purposes test may also be included. It's called denial of benefits clause. But such clauses, by contrast to principal purposes test, tend to focus more on the abuse of procedure and prevent the abuse of procedure rather than the abuse on merits, that you invoke tax treaty with the sole purpose or one of the principal purposes to benefit from the treaty, and you do it contradictory to the purpose of the provisions of the treaty. Such clauses typically do not exist under investment treaties. They focus on when you establish an entity that can seek protection under investment treaty. Like in Philip Morris case against Australia, when Australia changed domestic law to protect people from harmful effect of cigarettes, tobacco, and then the tobacco business in Australia was in big decline because of the change of legislation. But the investor didn't have investment treaty with the country of investor didn't have investment treaty with Australia. So they, anticipating the dispute with Australia for multi-billion dollar, established a company in Hong Kong, which had investment treaty with Australia. They stated that the sole reason to have a company in Hong Kong was to benefit from the Hong Kong-Australia treaty, which is not the purpose of investment treaties, which is to facilitate cross-border investments. There was no investment, really.
This was precisely one question I was going to make on the concept of indirect ownership. So we cannot do a treaty shopping for investment treaties to seek protection, right? It protects indirect ownership, but let's say justifiable indirect ownership, right? Not the one that was set up just for seeking protection. The case of this case you quoted of Australia may be different. This is the question because the law already existed and they reacted to the law seeking protection. But a Brazilian company willing to invest in Poland, where the courts are not impartial, and no, Brazil and Poland don't have an investment treaty. I could do the investment via, let's say, Luxembourg or Netherlands or some other jurisdiction that has a good investment treaty with Poland. Would that be considered, sort of treaty shopping for?
So can you hear me well? Because we changed the, okay. So treaty shopping is permissible under investment treaties and even more than under tax treaties because this threshold of the abuse of procedure is very high. The tribunal stated that it exists, it applies only to situations when you knew or it was reasonably foreseeable to know that there will be dispute. So the only reason that you establish that indirect intermediary is to benefit from investor-state dispute resolution method. The only thing you wanted from the treaty was the resolution method. Okay, then there is abuse. But if you did not know about dispute and it was not reasonably foreseeable, for example, you established a company in Netherlands or Luxembourg as a part of the holding strategy, and then there was a dispute 5 years later, then there is no abuse. Then the treaty shopping is permissible.
And just to emphasize this point, Victor, again, sorry folks for joining the group a bit late, but just to emphasize this point, having a holding structure with access to a network of investment treaties is permissible because the expectation is that there's not going to be a dispute. So you're not investing in order to have an issue of wrongful actions by the other states. So given that, the setup, the infrastructure is prepared exactly to inhibit wrongful acts. So the fact that you're setting up a structure, and in that structure you do have investment treaty protection, is perceived as in and of itself valid purpose, a valid business purpose. Meaning it ends up being valid as long as you're not volunteering into the structure with already the specific dispute on your radar.
Exactly.
If I may ask, if I may just add one thing, because I take it that many people hearing all this might be paying attention to these topics or thinking about this topic for the first time. And when you see all this protection, there has to, in so many countries, you know, we hear the UN, we hear the rumbling, we hear the noise. A lot of developing countries don't like investment treaties. What is the deal with this? Why all this protection? And there's a lot of good, not just customary international law rules and theory behind it, but there's a lot of let's say sociological and economic justification for it as well. Political science justification, which is a foreign investor does not participate in the political system of the invested state. So given that, it would be a corollary to freedom of enterprise, which is values that pretty much every country will have in their constitutional law. Constitutional laws. We also have it, and to let's say to foster ownership rights, the right to property. So all of these things, which tend to be fundamental rights in constitutional law, they end up being elevated to this public international law and customary international law status, because access to the local domestic political system is not the same between a domestic agent or a domestic investor and a foreign investor. So especially in investments of long term, so foreign direct investment, which is without a predetermined life, for example, in these sectors that Blazej has mentioned here, which is inherently long term, inherently risky. Having this type of protection is not only legal, but it's just, it makes sense. It ensures that those types of values that are typically constitutional, they're stable. So that's the point of the stability that we were saying before, just to make sure that this is not just about, capitalism as a value. No. It's about ownership rights, property rights, and let's say social standing within specific states. So sorry for the bit of intro.
Oh, it was excellent.
Just to make sure that the younger minds are catching the purpose.
It's excellent. When countries criticize ICDS, they often forget that similar or sometimes same standards, they have an own constitution, because they don't like arbitrators to decide cases. They want own judges to decide cases, because judges are appointed by the government depending on the constitutional framework. And there is this wave from one to another generation of people governing the countries. And sometimes you end up with dysfunctional judicial system. And then the legislative and executive power may go very far beyond bending the constitutional framework, sometimes breaking it. And judges are not willing to admit that, whereas investment treaty arbitrators will do so. They are outside the jurisdiction, they are protected, etc., etc. So the fact that countries like India and the countries on the UN forum decided to carve out tax-related disputes from investment treaty protection is disturbing. It increases the cost of investments, which means that it will contribute to decline of foreign investments. If countries suffer from the lack of sufficient infrastructure, be it digital or physical or intertwined, it will continue to be a difficult situation for people living there in the long term. So in the end, once you go through this definition of investor, investment, there must be a causal connection between how a state behaves and the financial damage. If there is no financial damage, there is really no goal. You need to prove that the action attributed to a state, and taxation will be always attributed to a state because private actors do not have power to tax, causes financial damage because of violation of investment treaty protection. Before we will go through these relevant standards from taxation, just to show you the concentration of the biggest winners in investment treaty arbitration. Here you have states from where claimants, so investors who decide to arbitrate, come from. US, no surprise, is number 1, Netherlands number 2, UK number 3. But oftentimes investors that arbitrate from Netherlands, they are wholly owned or controlled by the US investors. And US has never lost any investment treaty arbitration, although there were some against US. Countries that recently have been most often facing arbitration, you see it's Spain, Egypt, Venezuela, Peru. Why Spain is so high? Because of the dramatic change in the Spanish approach to renewable energy. Spain, around 10, slightly more years ago, swallowed the blue pillow given by EU Commission that investment in green energy is the best thing that Spain can do because of the exposition to solar energy, etc. So many tax breaks, many offerings, entire regulatory framework. But then Spain realized that these investments were not the best for the government, not in that quantity, not in to so far-reaching degree. So Spain decided to withdraw from promises given to investors. And then they decided to arbitrate against Spain. Around half cases Spain won, half cases lost, but the money to be paid and cost of arbitration were tremendous. If we single out Spain, they're just renewable energy cases, then Spain was not that bad. Here, comparison of my country of origin, Poland and Netherlands. You have on the left side, the Polish side, that there were nearly 40 cases against Poland and only 8 cases initiated by Polish investors. So we are on this wrong side of the spectrum, right? We lose much more than we gain from investment treaty protection as a country, both as for government and for investors. The opposite for Netherlands, more than 130 cases initiated from Netherlands against other states, the Dutch investors, and only 3 cases against Netherlands. And the first case was just in 2021, and out of these 3 cases, 2 were discontinued because there were intra-EU cases regarding the energy sector. And by the way, one of the companies that decided to arbitrate against Netherlands was controlled by Finland. So despite that there were 2 member states in the battlefield, there is no friendship.
And Blazej, just to emphasize one point you made, if you can give a bit more commentary on it. When you mentioned the number of cases and per country, etc., this is what is known, right? So not every case that is ruled ends up in the public knowledge, and there's a substantial amount of cases that are settled. So if you can comment on that, so that people can have a dimension that this is much bigger than 37 cases or 140 cases.
Yes, of course. And one case that I will discuss, it's a funny anecdote, is that a friend of mine, Professor Filip Balcerzak, used Polish domestic law, which says that everyone can have access to information regarding public domain. And if a country is sued by an investor, it belongs to public domain because the taxpayers' money will be paid as a compensation, right? So although the arbitration proceedings parties applying arbitration proceeding decided to make this case fully intransparent, private, he knew about that case, he went to court, he won the case in front of Supreme Court, and now we have access to that case. Otherwise, we would not have it. And I know that he's doing the same with other cases. So there is significant and current energy investors come and decide to arbitrate. Then other and current energy, which investors come and decide to arbitrate. Then other countries are of origin of investors arbitrating against Poland: Luxembourg, Cyprus, Isles of Man. So all 5 countries have common denominator. They are taxpayers friendly. They have a large network of tax treaties. And it means that in some cases that we know nothing about, it's likely that there were cases regarding taxation, that Poland mistreated foreign investors because of the change in the approach, change of the interpretation, or change in law. So we heard quite a lot about US, Netherlands, Poland, but we are in Brazil. So I would be very bad speaker if I close my eyes to Brazil. Brazil is difficult for investment treaty arbitration because it has only 3 treaties of that sort that are ratified with Mexico, Angola, and United Arab Emirates, and none of them has arbitration clause because that's the Brazilian constitutional stand. We think that anything related to what we do in Brazil can be decided only by Brazilian judiciary power, not by some arbitrators appointed by investor and us and some third arbitrator. And even if, assuming that Brazil has arbitration clause, which is not the case, you have, and you can read a very broad tax carve-out stating that nothing in this agreement shall apply to tax measures. Okay. So there is a double no for abuse of tax power by Brazilian government or legislator to be decided by investment treaty arbitration. So that's the problem for foreign investors entering the Brazilian market inbound. But for outbound Brazilian investments, investment treaty protection is relevant because of treaty shopping, because of possibility to have holdings in Netherlands or Luxembourg, etc., etc. And this is not only theory, it's practice. There are companies, there are some cases initiated by Brazilian investors. For example, Brazilian telecommunications company Oi initiated arbitration against Cape Verde on the basis of the investment treaty between Portugal and Cape Verde from 1990. Another example is the arbitration of Brazilian corporation BA Dassar Rolos through the company established in US and the state of Delaware against Argentina on the basis of the Argentina-US bilateral investment treaty. How to do it? Typical approach is similar to tax treaties. You just look for a country which has the most favorable network of investment treaty, or at least has an investment treaty which is most favorable in its content and has arbitration clause with a country that you want to invest. For example, a treaty between Netherlands or Switzerland and some African or South American countries. Another example, which is a way more nuanced and not that well known as well, is the concept of shareholders' reflective losses. It means that if you are a shareholder of a Brazilian multinational who suffers from aggressive taxation in some Asian country, for example, and as a result of that taxation, you receive much less dividends and the value of shares in which you investors drop down, you can arbitrate if you are national of a country which has investment treaty with the country that imposed that taxation. It's super relevant for Pillar 2. Because US and China are not part of Pillar 2, so their investment treaties would not be relevant. Investors from China and US would not arbitrate, for example, against income inclusion rule. Okay? But if there is US company traded on NASDAQ or New York State Exchange and has 9% or so, and it's a Swiss citizen or a Swiss company, then Switzerland has a lot of very good investment treaties protecting against abuse of tax power. They may consider it, for example, against Poland or against any EU member state, because Switzerland is not part of the EU. So it will not be subject to the so-called ACMEA case, if you have heard about it. In 2018, the Court of Justice decided in Achmea that investment treaty arbitration in EU is illegal. Why? Because an investment treaty tribunal does not meet the definition of a court or tribunal under EU treaties. Funny enough, a country which speaks the same language like you and arrived here in 1500 to Porto Seguro, which I am very lucky to visit tomorrow, has arbitration system for tax disputes. And the arbitrators and arbitration tribunal in Portugal, although appointed ad hoc, is not problematic for the Court of Justice, but investment treaty tribunals are. Why I said ad hoc? Because the key problem for the Court of Justice was that investment treaty tribunals are not permanent, whereas courts are permanent. You don't have just court for one case, whereas you have investment treaty tribunal only for one case. But the same you have in Portugal, and Portuguese arbitration system is not seen illegal under EU law. So of course it was party political, because through the treaties in 1990s and after 2000, EU Commission got discretionary power to decide about foreign policy regarding trade and investment. And allowing investment treaty arbitration tribunals decide cases regarding investment will diminish the power, the exclusive power of the Commission. So there was a kind of pressure from the Commission to push the court towards that direction. The Commission was doing that since 1993, an Energy Charter Treaty in which Commission wanted to add a carve-out for that and say Energy Charter Treaty in respect of the investment in energy in EU will not apply because we as EU Commission will take care of. Right? It failed. It didn't happen. Countries didn't agree on it. Example regarding outbound investment and consideration of protection under investment treaties is that regarding Suriname's market, because Suriname opened beef market for Brazilian beef M&Es. And of course, there is no investment treaty between Brazil and Suriname. Yes, which means it's not legally, yeah. But if you think about it a little bit, then you will figure out that there is very good investment treaty between Suriname and Netherlands, which also protects against abuse of fiscal power. So if you invest a lot of money in Suriname to be #1 beef exporter, seller, and Suriname will realize that it's very profitable and will impose special taxation that will hit only Brazilian entity or Brazilian entities, then the only way how you can fight against that discriminatory tax treatment is through Suriname domestic judiciary system. By contrast to investment treaty protection and the choice of procedure and choice of arbitrator, etc., under the Suriname Netherlands tax treaty, investment treaty. So it's no brainer that you will go through Amsterdam. And going back to your question, it will not be abuse of the treaty. It will not be abusive treaty shopping, because as Romero pointed out, Brazilian investors do not enter Suriname through Amsterdam because they have planned to arbitrate against Suriname. It's the opposite true. They hope that it will never happen, that it will be valid to even consider that.
There's one point that you have mentioned. There's one point also, Blazej, that you have mentioned, which I think is worth emphasizing here, which is this definition of discriminatory treatment being de facto, not only de jure. Mm-hmm. So even in our constitutional law, a lot of times it's difficult to make the de facto argument. So for instance, if there's no specific law targeting the Brazilian multinational or Brazilian beef, but if it says that companies with a certain profile or that achieve a certain level of profit or that are in a certain, meaning it ends up applying only to you, that ends up being a factor. It's a de facto situation. So, I mean, it's a much broader and facts-driven analysis, right? So it's
Yes.
not the letter of the law.
Exactly. We will have that case discussed. 5 more minutes and break.
Yes.
Okay. So I will go quickly through statistics, and then we have break, and we start with analysis of 3 selected cases. The table on the left side reflects the number of all investment treaty arbitration cases by 2021, nearly 1,200. Now it's around 1,300, I think. And on the right hand, you see the increase in tax-related cases from merely 3 by 1999 to more than 120 as of today. So it is non-negligible percentage. It's around 14% of all cases globally are tax-related. And by tax-related, I mean that taxation was the core reason why investor stated or observed that the state violated the investment treaty. Here are selection of behavior of states through tax power that have been challenged by investors under investment treaties. Sometimes successfully, sometimes less successfully. Retroactive taxation, also constitutionally precluded, typically. Violation of tax treaty commitments, also constitutionally precluded as per lex specialis in Brazil or lex superior in other states. Premature revocation of tax incentives. That depends, of course. Breaching tax stabilization clauses, similar. Discretionary or protectionist taxation. I think it's often also referred in the Constitution that discrimination is prohibited unless justified. Confiscatory taxation. So protection against expropriation, not only protected under Constitution, but also customary international law. And windfall taxation. So when you have like stroke of luck, you are in oil industry and there is a war in some part of the world, and therefore there is a spike in the price, and then countries often have this extra taxation, also in EU through regulation. One thing is the nominal number of cases or percentage. Another thing is the money. It's like with lawyers. One lawyer will tell you, you know, I am the best tax lawyer in Brazil because I have 50 cases per year. And then you say, oh, I have only 2, but how much money you made out of it? You know? So if you look at the money, then tax-related cases belong to the largest in the history of dispute resolution of any kind, not only investment treaty arbitration. Occidental versus Ecuador, 1.7 billion, and it was 13 years ago. So factor in inflation, it will be much more today. Yukos case, the largest in the history, the claim was for nearly 120 US billion, and the compensation to be paid 50 billion. Of course, Russia never admitted that, never agreed to pay it. Carroll versus India, claim for 5 billion, paid 1.2 billion. By the way, when you see a big divergence between the amount of claim by investors and the amount of compensation, let's say 5 times less, it doesn't mean that investor lost on the money, in respect of money. It's just a practice. It's almost custom that they will always ask for more arbitrators. And the last big case, Stati versus Kazakhstan. Okay. First case, Ecuador. Just Ecuador suddenly changed the way of understanding of the stabilization clause in respect of VAT calculation and VAT refund. Yukos versus Russia. It's a very sad case. The entire investment was destroyed for non-tax reasons, really. But I will refer to it a bit later. And Carroll versus India, retroactive taxation, we will discuss it after the break, which bypassed the judgment of Supreme Court. Here you see the sectors on the left side, which most likely are sectors of relevance for investors that decide to arbitrate. By far, energy sector, by far. Okay? And by geopolitical experts, clean energy, renewable energy belongs to top mega trends in the world. So energy sector will continue and extractives to be the top sector in investment treaty arbitration. Also information and communication, any type of high technology, AI may belong to that sphere as well. And then what tax is most destructive? Typically combination of many taxes with aggressive tax audits by tax authorities. But if you want to single out one, then corporate income taxes outstanding, followed by VAT. What type of investment treaty protection is most likely invoked by investors against states? Fair and equitable treatment in generally, in all types of cases, and also in respect of tax-related cases, and followed by indirect expropriation, and then you have combination of fair and equitable treatment and non-discriminatory treatment, etc., etc. And until here, you may say, you refer to some old cases from 2020. It's not that old, 5 years, but for some, everything is old, which is older than 2 weeks. But here you have 3 pending cases. They are still ongoing. You may follow it. You may look who, how is leading those cases, where is the law firm, maybe you know the counsel, etc., etc. So you have Shell, Philippines versus Philippines case, which just in May 2025 reached the stage of merits. Until then, there was disputed whether the Dutch-Philippines investment treaty may be activated against taxation, retroactive taxation, and the majority of tribunal, 2 out of 3 arbitrators decided that yes. So now the case is continued on merits against retroactive taxation. Another case, Ansheur-Bush InBev against Peru for 500 million. So the first case is for 1,100,000,000, second for 500 million US dollars. And the last one is huge, AXA, investor from France against Mexico, challenging taxation measure regarding prohibition of VAT crediting on claims related expenses for nearly 9 billion US dollars. Case registered in late 2024, so still early stage. Okay. I think that we all deserve for 10, 15 minutes break, and then we will continue.
Yeah, exactly. We will stop the recording and the transmission. We'll be back in 15 minutes. So in my watch, 8:30. The question is, would that apply to network as well? Isn't it also for that? Not the case in Brazil, we don't have a investment procedure. Would that cause investment?
Maybe, but I'm not sure if I can say it. No, we can discuss it.
Perfeito. Okay, let's go back and start our second part of the presentation. Please, Blazej.
Okay, great. So it's custom for me to move when I speak. Okay. And can we see slides again? The presentation from. So first, I will draw your attention to investment treaty protection standards, those of the highest relevance to tax cases, but very briefly, because what I really want to show you are cases, how this law works in action. So fair and equitable treatment, the broadest really standard, it consists of several principles, prohibition against arbitrary treatment, against discriminatory treatment, protection of legitimate expectations, etc. So it will be relevant, for example, if you think about Pillar 2, if Brazil or any other country with domestic Pillar 2 rules, also defending rule like UDMTT, have very specific legislation. And in this legislation, you have parameters, once met by investors, then investor can benefit from tax holidays for, let's say, 10 or 15 years. The longer, the stronger the protection. And then there is this 15% raise from 0 to 15% under Pillar 2. The question would be, is it fair and equitable to investor to break this tax holiday because of Pillar 2? What would be the justification, considering that Pillar 2 is not preventing harmful tax competition, but any tax competition? And what tax competition is also questionable. In other words, the purpose of Pillar 2 is not clear enough, especially now when there is a strong opposition of US against Pillar 2, and countries will face the solution-making approach in inclusive framework. And we know that 28 countries, including countries like France, Belgium, Germany, China, are not convinced that that's a good approach to carve out or single out one state, MNEs from one state, and treat them differently, right? Why not also theirs? Fair and equitable treatment also requires states to act in good faith. Okay? So if a state legislates tax law in a way that the result of application is discriminatory for only for investors from one country, is it acting in good faith to increase state budget from taxation for public purposes? Or maybe the purpose is not public, maybe the purpose is specific to eliminate that investor from the local market. Expropriation, when we talk about expropriation and taxation, we have in mind indirect expropriation, because direct expropriation is a direct taking. States come to you and say, from tomorrow I will own or I will control that investor, that investment by law or by order. Indirect, because through taxation. The example of direct expropriation, COP versus Venezuela case, when Venezuela just seized the assets of Chavez oil site. Indirect, Yukos versus Russia, where Russia applied domestic tax law so aggressively, both direct taxation on corporates and VAT, and required to pay astronomical tax bills in a few days, in a very short time, without really possibility to challenge these decisions, that investor collapsed. There was liquidation of the investor and taking as a result of that, of failure to pay all tax bills. Expropriation per se is not illegal under domestic or international law. It becomes illegal if it does not trigger a fair and adequate and prompt payment. Okay? So a state can, for example, overtake ownership of your home if they plan to build highway there, but they needed to tell you in advance, they need to pay for it and do it promptly and fairly. Umbrella clauses already mentioned, but a little bit more now. Umbrella clause is fascinating because of the simplicity of the language and far-reaching effect. Simplicity because it uses the phrase that the state shall observe obligations undertaken in respect of investment. And this word observe, although doesn't sound strong, it's very strong, because through case law, observe means to respect, to not violate, to not deviate, to not surprise investors due to the contract between state and investor. Absent investment treaty, a contract between state and investor will never reach the level of international protection. An example how umbrella clause can be activated: tax holidays, tax stabilization clauses, but also maybe through advanced tax ruling, which is then abandoned, advanced transfer pricing agreements, production sharing contracts, special economic zones. And there was even argument in the Lone Star case that you can extrapolate from tax treaties a state promise to treat you in a certain way. So if there is denial of benefits under tax treaty without the proper interpretation through Vienna Convention or without principal purposes test, then this argument for umbrella clause may be also relevant.
Let me add something very briefly. It may sound odd, awkward to the audience that tax is part of a contract of a company with the state, right? we were speaking before about stabilization clauses in Latin America in general. You know, in Brazil, we do that a lot through regime especial for the VAT. You know, we put the tax in an agreement with the state. So we're talking about something that we don't normally do with foreign investors, but many countries do, especially for long-term investments in the oil, energy sectors. So this is something very common.
And we also have built into a lot of our concessions.
Yes.
So if we think about concessions, there's a lot of terms for certain types of adjustments based on tax law changes, which is exactly to preserve the notion of that concession, the balance of that investment that was made if it was a privatized sector. So we do have that parsed out in our system here. And I think one point that is very interesting too, just to highlight that, is your point, Blazej, of interpretation override. So you basically, if there's a change of reading, you're reading the transfer pricing law differently, you're applying the treaty differently, that might be constituting a violation in the sense that you're changing the stance based upon which the investment decision was made. So this is a very subtle point, and for us, if we had these treaties in Brazil, can we imagine?
Yeah, you have change of interpretation without equivalent or proportional change of the context. So facts and circumstances are equal as before. So why the change of interpretation? Okay, what is the reason? Is it good faith change or bad faith? Here is an example in the Mexican cases how non-discrimination protects foreign investors. It says that foreign investors should be treated in the same way like domestic in like circumstances. And here we had a case. It's a fascinating case. It has many layers. I will go just through a few of them briefly, in which Mexico imposed 20% tax on high fructose corn syrup. Therefore, this abbreviation HFCS refers to that and is used more than 100 times in the case, but not on sugar cane. Why? Because sugar cane was the basis for production in Mexico, whereas corn in US. So legally, de jure, there was no discrimination. But de facto, 99.99% of the Mexican producers of sugar were carved out. And by the way, that's not the end of the story, because discrimination may have also faced, which is called protectionism. When you protect domestic against foreign, it may have even deeper layer. Within the country, discrimination may discriminate private against public. State-owned companies are de facto not de jure treated better than private one. For example, think about tax audits in respect of withholding taxation and beneficial owner. I could say that in many countries, if you would get access to public information about tax audits and you will ask how many tax audits have been targeting state-owned companies in respect to cross-border payments of dividends, interest, and royalties, and how many of them ended up with increase because of the lack of beneficial owner, right? If the answer will be 0 and 100% private market, then you have this type of discrimination or protectionism. And here, that was that example because almost 100% of the companies in the sugar business in Mexico were state-owned or controlled. What the tribunal decided, and similar reasoning was in Mexican case. Here is the reasoning from Occidental versus Ecuador. The tribunal is convinced that this has not been done with the intent of discriminating against foreign companies. Legal intention. What mattered is the result of the policy enacted and the interpretation followed by SRI, which is like tax authorities in Ecuador. In fact, has been less favorable treatment of the foreign investor. So what matters is the result of application, considering facts, not only the wording of the law. This type of discrimination is typically not covered by tax treaties. In tax treaties, typically is direct de jure discrimination because of the residence, right? Although they are different case law and these clauses may be worded differently.
And it's interesting because this is a standard that has developed over time under investment law. Because, for instance, if we have some of the same notions of non-discrimination, equality of treatment under constitutional law, in different countries, those terms will have different meanings in different countries. Sometimes they'll be as broad as this, sometimes they will not. But the point is that under this rule, you have a defined standard, which is global.
And as a result of these cases against Mexico, Feldman case against Mexico, but also Arhem Daniels case against Mexico and one more, only investors they decided to arbitrate got compensation back. Those who didn't. And as a result of this arbitration, Mexico was forced de facto, not legally, to change legislation because they didn't want to risk more arbitration. But this case has second bottom. The Mexico defended itself in many ways. And one of the defense is relevant when you think about what happens in US and retaliatory tariffs and potentially retaliatory taxation like Section 899, which was dropped, and Section 891, which still exists. Namely, Mexico stated that the reason for this taxation, of course, they didn't admit it's discriminatory, but they said, even if tribunal will find that it's discriminatory, the discrimination is justified because we are doing due to the fact that the US violated NAFTA and doesn't want to comply with NAFTA. So now we violate NAFTA. It's the reasoning on US in respect of Pillar 2. We may violate tax treaties, we will not respect tax treaties because you discriminate against US companies. The same for DSTs. But international law, customary international law, codified and not codified, says that you can apply countermeasures, defend yourself against, for example, discrimination from the side of foreign states, but it must be a proportional response. It must commensurate with the injury suffered. This word injury comes from the fact that countermeasures emerge under customary international law in respect of the armed conflicts in military settings. But then they were, by analogy, developed in non-military settings, in commercial settings, like violation of trade treaties, and why not in tax treaties or investment treaties? Okay. Of course, we talked about standards, but there is always deviation from standards or there are nuances. And the new generation of investment treaties, like post-2015, let's say, so around the BEPS period, started to include denial of benefits clauses, which is similar to limitation on benefits clauses or principal purposes tests, but not that aggressive. Also, in new investment treaties, you will find requirements for investor or investments by reference to substantive business activities. But case law is quite forgiving. A company without any substance under tax law would be considered to have enough substance under this requirement of substantive activities. And another, you would say, very basic element that you learn as a student of the first year of tax law in tax school, what is the definition of tax? But you'll be surprised how many tax advisors will not tell you immediately what is the definition of tax. So here is the definition of tax as extrapolated by arbitrators from domestic law, comparative analysis, and international law. Tax measure, or tax, exists where there is a law. So tax must always come from law, rule of law, that imposes a liability on classes of persons to pay money, not potatoes, for example, but money for public purposes. And why I emphasize this last element for public purposes? Because if you meet all these three elements, so you have tax law, that impose liability to pay money on certain group of persons, but it is not done for public purposes, then it is not a tax, it's a tax in bad faith. And what does it mean? It means that it's not the use of tax, it's the abuse of tax. And there are two cases that exemplify this very well. Russia, Yukos versus Russia, extreme case. So here you see that the tribunal dealing with the tax carve-out under Energy Charter Treaty started to create really a new concept, the so-called bona fide versus mala fide taxation. Why? Because Energy Charter Treaty had very complex tax carve-out. And Russia stated, whatever we done through tax law is not the matter under Energy Charter Treaty, okay, because the carve-out. And this is what tribunal stated. The tribunal finds that in any event, the carve-out under Article 21.1 can apply only to bona fide taxation actions, actions that are motivated by the purpose of raising general revenue for the state. By contrast, actions that are taken only under the guise of taxation, but in reality aim to achieve an entirely unrelated purpose, in brackets, such as the destruction of the company or the elimination of a political opponent, cannot qualify for exemption for the protection standards of the Energy Charter Treaty under the taxation carve-out. Very powerful. Imagine the president of Brazil will use the tax authorities in the state of Bahia to eliminate its political opponent through aggressive tax audits that will end up with destruction of the business of that gentleman. In Yukos, it was between two powerful men, and one ended up in jail and got protection under the jurisdiction in the United Kingdom. Okay, so it was very far-reaching. Now, less egregious case, Poland. Tribunal did not admit per se that Poland applied mala fide and bad faith tax law. Did not say that explicitly, but implicitly it did. Namely, POG refers to podatek od gier, which means the tax on games, like gambling games. The tribunal observed, although the increase of this tax on gambling was a taxation measure on its face, it was not in fact aimed at increasing the state's revenue. Okay? Moreover, as a result of that drastic increase of taxation in Poland, entire gambling business stopped to have any commercial sense. Tax consumes all profits. So there was big exodus from Poland. And then the tribunal reasoning was similar to the economic approach of Adam Smith about the source of income. You cannot suck so much from the source of income that you are leaving taxpayers with nothing, because tomorrow you will have no tax to be charged from. So it must be proportionate, and it was disproportionate. So the fundamental concept that we tend to disregard as tax expert, like good faith, bad faith, proportional, disproportional, are foundational concepts to distinguish between the use and abuse of state's power. There's a difference between spotting how state should apply and should not apply, and whether you have or you don't have protection under investment treaties, even if there is tax carve-out. So there is argument also for people that stems mainly from ignorance. In my country, investment treaties have tax carve-outs. Okay, fine. But you need to look closely how tax authorities behave in your country, because maybe it was not application of taxation measures, maybe it was misapplication of taxation measures. So funny, not funny, treaties have principal purposes tests now through MLI or bilaterally like in Brazil, but taxpayers do not have PPT against tax authorities. They have implicit PPT against tax authorities only in investment treaties. Therefore, United Nations decided to carve out taxation, and this carve out is without any qualification. Therefore, I wrote this article in my newsletter that it's too far-reaching, because this UN carve out deprives protection even in respect to cases such far-reaching like Yukos case, when there was an obvious abuse of the tax system, not the use but abuse. Okay. First case, so let's see how investment treaties work in practice. This gambling case called Hortel and Aberta versus Poland, decided in 2017, so it's relatively recent if we look at the entire history. Respondent state was Poland. By the way, I did this breakdown because this is how investment lawyers look by parameters. Okay, you invest in Poland. Look at the investment treaty, which is the best. In Netherlands, also the Netherlands, you see the investment treaty was 1992. Poland had only 3 years since the Berlin Wall collapsed in 1981. All Western countries concluded investment treaties with the former Soviet Union countries, and Poland was not Soviet Union country, for those who don't know that, but we are under the influence because of the deal in Yalta and Potsdam, unfortunately. The influence of Stalin was all the way to the half part of Berlin and to the Trieste, from Stettin to Trieste. So we didn't have economic freedom. We didn't have freedom in general until 1989. So we were El Dorado for investors. whatever you invest in Poland, it gave you back 100 or 1000% back. But legal framework was not put in place. Therefore, investment treaties to protect it. Okay. So you have investment treaty with Netherlands. You have business operation slot machines. And there was a new law about it in 2009 called gambling law. Okay? And this gambling law restricted operation of gambling machines and also imposed a drastic increase in taxation on it. Why? I will soon explain. The rules, procedural rules, uncitral rules. The seat of arbitration was in The Hague in Netherlands, Permanent Court of Arbitration. And seat of arbitration doesn't mean physical place. It's the law that is decisive for the procedure. So if Poland would like to challenge that award, that decision, it will have to do before Dutch courts. The investor claimed quarter billion Polish zloty, got around 40 million Polish zloty. So the sharp increase of effective taxation. Why? Because of the political scandal. Journalist investigation revealed that high senior members of the parliament and government were involved in lobbying for that law to allow foreign investors enter Poland and have the gambling business. And therefore, Prime Minister, to try to save the face, decided to eliminate entire business. So again, when you think about it, if he acted in accordance with the principle of proportionality, he will not destroy entire business. He will just change the law according to these doubts regarding the lobbying effect, okay? Too far-reaching. But because he went too far, and this case was not in public domain. Because of my friend, it became public domain, so we can discuss it now. And how this treaty between Poland and Netherlands, investment treaty, applied by the tribunal. The core element. The core element regarded the change in tax law and the legitimate expectations. So here in blue, you can see that it was also mentioned by Romero before. Every state has right to change the law. And there is no legitimate expectation that the law will not be changed. Okay. But legitimate expectation exists that change in law does not deprive an investment its economic sense. Because if not, then it will be too risky to invest in any country where there is tax system. Paragraph 254 exemplifies that very well, illustrates that. The tribunal follows. That being said, by issuing the relevant gambling permits, Poland specifically undertook vis-à-vis the permit holders, foreign investors, to allow the permitted activity in 6 years, similar to stabilization clause, right? This undertaking would be rendered illusory if in meantime Poland could change the taxes applicable to the industry in a manner that would fundamentally alter the economic conditions of the permitted activity. So fundamental change to the permitted activity is not through taxation, is not the use of taxation, but it's abuse of taxation. And this investment treaty protected it against its use. And then the tribunal continued that the tax on gambling was a taxation measure on its face, falling to increase the state's revenues. So it was failing, so it was bad faith, thereby causing a large number of permitted machines to stop operating. So it was almost expropriatory effect. Okay.
And just to emphasize one thing, which might be subtle for some people, how is it that an increase in tax is not raising revenue? It's because you're taxing the business out of business. So yes, that's the whole point. So it is an increase in tax. Yes, it is an increase in tax, but it does not seek an increase in revenue.
Yes.
Or in this way, it doesn't result in an increase in revenue. It could even be seeking an increase in revenue, but not resulting in an increase in revenue.
Yeah. And there was the observation, like the result was the exodus of the business. Mm-hmm. So how they can pay taxes. Okay. Another case, we now traveled from Poland to India, a case decided in late 2020, a way more complicated case. so it takes a bit more time to go through it. Again, respondent state India, home state of investors United Kingdom. You had several companies, Carn Energy, Carn United Kingdom Holding Company, etc. The similar case of India to Poland, in a way that India also in early 1990s went through the economic and legal transformation, received money from IMF and World Bank Group to put in place infrastructure and attract foreign investors. A package to attract foreign investors included also those that came in oil and gas industry. So they operated in oil and gas, petroleum and natural gas. Again, unilateral rules, again, seat of arbitration in Netherlands. See, they could choose different. They could choose Switzerland, they could choose UK, but Netherlands is very often chosen for the place of arbitration. Also in UK's case. So think about it a bit. How much country can gain reputation and traction with the most serious businesses and legal cases if country is open to arbitration, right? Every person, every lawyer, every judge, every clerk in Netherlands earns money and pays taxes from this money because Netherlands attracts that. We know about, when we think about Netherlands as tax lawyers, we only or mainly think about tax treaties. We don't see this. And this is sometimes way more at stake than under tax treaties. Claim astronomical, more than $5 billion US, awarded more than $1 billion US, $1 billion 200 million, similar to Vodafone case, the Dodge investor. Let's look at the facts a bit, which are a bit complicated, especially that there are some abbreviations. So the Carn Energy consolidated 27 subsidiaries that were active in the oil. They were like the companies that really did the stuff operationally, exploit one of the largest, if not the largest back then, oil field discovered on Indian soil. And then they transferred shares from all these 27 subsidiaries to newly established holding in the UK in exchange of the shares with that company. So the Carn Energy transferred the shares from 27 subsidiaries to newly established holding in UK. And that newly established holding incorporated another holding called Carn India Holding, although the name India, but it was in Jersey. And here they admitted that the sole reason to do it was to avoid 2.5% stamp tax in UK, because there was not stamp tax in UK. And they transferred the shares to that company in Jersey. And then the transfer of all of the Indian assets of the Carn Group were done to newly established company SEAL, Carn India Limited Company. Why? Because the purpose was to enter into Bombay Stock Exchange. And under the regulatory regime in India, only Indian company can enter Indian Stock Exchange. So they have done it in that way to meet the regulatory requirements to enter into stock exchange. This is just the illustration that this transaction was effectively exchange of shares between two non-Indian companies. So Indian domestic law, as domestic law of most countries in the world, do not have jurisdiction to tax in respect of exchange of shares between two non-residents, be it domestic law, be it, of course, tax treaties as well, apart from specific wording. Okay, so core of the dispute. The core of the dispute stemmed from the interpretation of income tax in India from 1961, which did not impose tax on indirect transfers of capital assets situated in India. So what India done? As a result of tax audit in Hutchison Vodafone case, they reinterpreted for the first time in the history domestic tax code and stated by means of extensive interpretation against taxpayers, which is often, by the way, precluded by constitution, you can, by analogy or extensively interpreted tax law in favor of taxpayers, not against. Here it was against. Namely, they stated that as long as the value of shares which are exchanged between two non-resident companies comes from the Indian soil, and of course oil and gas did, it is subject to tax in India. They came to this idea. The case was litigated and ended up at the Supreme Court level in India, and the famous judgment from 20 Jan 2012, Vodafone versus Union of India. Very good judgment, really worth reading. It's in English. And the judgment was against India. It was in favor of the taxpayers. In Indian courts, Indian judges said there was no doubt that this is improper interpretation. This transaction cannot be captured by Indian tax system unless the law changes for prospective transactions. So what India did? Ministry of Finance proposed to change the law, and they changed the law, and the new law stated that, I don't know if I have it, no, not yet. The new law stated that this interpretation provided before by Ministry of Finance should always be applicable. So it was retroactive taxation de facto through the change in law, retroactive change in law, going back to 1961. But then the Ministry of Finance said that in India we have 5 years of termination for tax audits, so it's only 5 years back. But for the maximum period, it was retroactive. It was taken out of surprise. India also defended itself fiercely by stating that investment treaties, investment tribunals have no jurisdiction to decide tax cases, and this is tax case. At most, they can the case can be taken under UK-India tax treaty through mutual agreement procedure. And the tribunal disagreed. The tribunal distinguished for the first time in the history between tax case and tax-related investment case. It says, in a tax dispute, the question is whether and how a particular transaction is taxable under the applicable domestic law or possibly laws of several countries if the transaction is international, like the clash under tax treaties when there's source state and resident state. In tax-related investment disputes, on the other hand, the tribunal is tasked with determining whether the respondent state has breached substantive standards of treatment under the investment treaty through the exercise of its authority in the field of taxation and whether liability arises as a result. The issue at stake is thus not a matter of domestic tax law. It is rather whether the fiscal measures taken by the state, valid or not under its own tax laws, also constitutional, violate international law. So there is this distinction, right? And this distinction was not liked by India and by UN later on. They said, okay, now we cannot really effectively defend ourselves by saying that investment treaties are not about taxation, because the tribunal in current case stated we talk about different legal regime. Even constitution, which is supreme law in a country, it's still the country law. We talk about international standard on which India agreed with UK. So no one forced India to enter into treaty with UK or Netherlands to start with. They did it in the early 1990s because with investment treaties, they would be not multi-billion-dollar investment in India, allowing to India gain enough money, enough technology to, for example, find and exploit this oil and gas. So everything is nice when someone comes and gives you money, but it's bad when they want to take the money back partly as a return from investment later. Okay. Now, here are observations which are very, very, very interesting for all of you that deal with tax planning versus tax avoidance versus when you deal to be simple between the distinction. So distinction is about legitimate tax planning versus abusive tax avoidance. It was the line of defense for India, one of many, the last one, stating that, okay, even if it was retroactive, and they disagreed, even if it was retroactive, we just wanted to prevent abusive tax avoidance. So India stated that the facts that you faced before, at the beginning of explanation of that case, led to conclusion that it was abusive tax avoidance. Okay. So the tribunal, consisting of 3 arbitrators having no clue what tax avoidance is, they appointed expert witness. One was appointed by India, another was appointed by, in that case, by Carn. And I don't know if I can say, but I approached the council in the case, and they provided me with the reports for research purposes. So you can find a bit more in my articles. So maybe I will not say the names, but in articles you can find the merits here. So the council and expert witness provided arbitrators with a meticulous analysis of the substance of reform, anti-tax avoidance judicial doctrine in India. And they tested this doctrine against the facts and case to conclude whether it was abusive or not, to start with the transaction. And here, what the tribunal observed. The mere fact that the transaction does not result in taxes being paid anywhere in the world is not insufficient to establish tax avoidance. Okay? You need to look into dominant purpose of avoiding an application in India. The way that Carn dealt with its tax concerns falls within the legitimate tax planning end of the tax planning tax avoidance spectrum. So they put it on the spectrum. Indian law recognizes that there is a difference between a party's avoiding the application of an existing tax and creating a structure that is tax efficient. So the tribunal does not accept that given this pre-existing situation, the price of gaining access to Indian capital markets to take company into Bombay Stock Exchange was for Carn to employ the least tax efficient structure. How nice. This reference paying tax anywhere was taken because India used the BEPS language of the OECD. That was used also multiple times to justify Pillar 2. And it was before Pillar 2, so the arbitrator stated, this is the policy matter. Arbitrators decide on law, not on policy. So first observation was that this particular case was not abusive tax avoidance, therefore the justification fails of India. Justification of India regarding tax avoidance fails also for different reasons. So the tribunal tested whether the violation of principle of legal certainty can be justified by public purpose, which is, in that case, prevention of abusive tax avoidance. And here are the observations. How to measure whether it is justified to violate principle of legal certainty versus not. And why it is so indicative, so relevant for PPT, for example, or BO, because then we deal also with facts that regard either to point towards legitimate tax planning or abusive tax avoidance. And the tribunal found principle of proportionality to be the one that should be applicable to help to find the distinction between planning and avoidance. The appropriate balance between the individual's interest of legal certainty, stability, predictability on the one hand, and the state's power to regulate in the public interest on the other, like in taxes, should be struck by reference to the principles of reasonableness and proportionality. This retroactive change in the law, called 2012 amendment, does not target foreign investors who evade or wrongly avoid taxes. It applies to any indirect transfer, whether tax abusive or not. So at the level of law, they also failed because the legislation was not bespoke to prevent abusive tax avoidance. The same like Pillar 2 is not bespoke to prevent harmful tax competition or tax avoidance. The very fact that in some cases it will does not rectify the observation that legally Pillar 2 is not bespoke to that. And then the tribunal continues, the respondent, India, did not have a specific purpose that would justify application, this retroactive taxation. As a result, India retroactive application to Carn failed to balance, or at least adequately balance, the claimant's protected interests of legal certainty, stability, predictability on the one hand, and the respondent's power to regulate in the public interest on the other. It was grossly unfair to change law retroactively to the maximum possible time. And now think about Pillar 2 and using this reasoning of the tribunal. Would be justified to increase taxation from 0 to 15 if investor was told or entered into contract with a state 10 years before Pillar 2 entered into force. At least a state should offer or enter into a reconciliatory discussion with investor impacted negatively by QDMTT, IRR, or UTPR to talk about qualified tax credits or non-tax subsidies, etc. If you want to read more about that case, it's open access Oxford University Press article by Stefan Weigel and myself, and we go there to the bottom of that case. Last case I want to share with you, Lone Star versus Korea. And here I can use names because you can find them in the award, so I'm not violating any law. There were two expert witnesses in this case. One appointed by Korea, Stefan Weigel, and another one appointed by Lone Star Funds from US, Luc Debreu. You may have heard about both of them. Let's look at the case. So we have Korea as respondent state, and the investor, US private equity funds, relied on the Belgium-Luxembourg treaty, investment treaty with Korea. It's called Blazej because it consists not only Belgium and Luxembourg. Back in the days, Belgium and Luxembourg team negotiating investment treaties acted in concert. And it's old one, you see, from 1974. That company, so the US private equity funds through Luxembourgish and Belgian companies, special purpose vehicles, invested into real estate market in Korea during a serious economic distress. So the Lone Star funds in US specialize themselves in investing into assets that are in distress because they lose the value. So if they anticipate that the economy will rebound in Korea, which happened, they will gain a massive increase in value rather than investing in markets that everything is fine. It's like knowing that there will be COVID or knowing that there will be war and you invest in that time of a difficult time. Here, we have different rules of arbitration, not UNCITRAL, but ICSID, and different seat of arbitration. No Hague, no Netherlands, but ICSID. And ICSID is interesting because it's completely delocalized. Administrative institution is in Washington, DC, in the underground of the building of World Bank Group, but under the law is nowhere. There is no single law that would refer to it in terms of it Chinese or it's Swiss. Nearly 5 billion claim, a lot, and the award, the compensation, only 216 million. The part of the claim that regarded taxation was $1.6 billion US, so a lot. And the tribunal completely disagreed with the investor. And you will see why. Because of the facts. Okay, so facts were as follows. You had Lone Star Funds, LSVs, established in US and in Bermuda as limited tax transparent partnerships. And they invested indirectly through Belgium, special purpose vehicles, and also partly Luxembourg in Korean companies. That's the simple structure. So they acquired the majority of shares in one of the largest Korean exchange bank, in arbitration KIB in 2003. And they also acquired shares in Starch Tower Corporation in Korea. And as a result of the enormous increase in the value of shares in both entities, they wanted to materialize the investment through disposal of shares and also dividend. They received dividend. And the question was whether tax treaty between Korea and Belgium applies, and therefore there's exemption and reduced tax rates in respect of dividends and capital gains exemption. The core of the tax dispute related to $1.5 billion US to be exempt under the treaty or lower taxation by contrast to the domestic tax law in Korea. And that treaty did not include PPT, of course. It was old treaty or any other clause of that sort. So what Korean tax authorities did, they applied domestic anti-avoidance judicial doctrine called substance over form doctrine, established and developed by Supreme Court of Korea. You can read more about it in 2018 IFA report of Korean reporters. As a result of application of that domestic anti-avoidance doctrine, they disregarded Belgium entities and they, as a result, denied the benefits under the tax treaty between Korea and Belgium. Why? here are the facts that were not disputed, that were gathered by tax authorities and acknowledged by the judges of all instances. Star Tower Corporation did not perform any business activities, nor did Start Holding SCA, this Belgium company. The only activity was transferring the shares. Start Holdings SCA, this entities from Belgium seeking benefits under the treaty with Korea, had only a single employee in 2003, although it received hundreds of billions of US dollars. One day after the sale of the Star Tower building closed, Start Holdings boards of directors, so boards of directors of that Belgian intermediary, met and agreed to liquidate the company. There was no specific material supporting that the Belgian company and its upper level holding companies conducted substantive business activities. In other words, there was no economic substance, or at least not adequate substance, to manage this transaction regarding multi-billion-dollar payments. And therefore, they decided that there was no violation of the treaty by denial of benefits under tax treaty through domestic substance over form doctrine. So the tribunal agreed actually with the expert witness report of Stefan Weigel that to apply substance over form doctrine or similar doctrine like economic substance doctrine to deny benefits under tax treaties is not something that is not a deviation from tax treaty practice. By contrast, you can find it in tax treaty practice on many states and in legislation as well. If you want to read more about that case, there's also an open access from the level of repository of Singapore Management University, where I am affiliated with. If you go to the website of ITSI's review, they will seek from you money. So you can choose by yourself. Okay. So now there's the last part I want to touch upon Pillar 2 a bit more. I was just scratching the surface a bit. Let's look a bit closer. So far, you follow me, or you have some questions, or everything is fine? Yes.
Give her the mic because we're recording.
I think you're gonna address this question when you talk about Pillar 2, but I was wondering how to reconcile the no benefit requirement with the QDMTT, because with pre-existing international investment agreements, because I think this is a breach of international law, because we had international investment agreements that pre-existing for Pillar 2, and then we have the QDMTT, for example. How to reconcile? Because if I apply the QDMTT, I'm forbidden to concede a relief to my investor. How to reconcile this? Because I think we're gonna have a problem under investment agreements. So that's my question.
Let's go through slides indeed, and then we should find the answer somehow. I hope so. Because of the interconnection between QDMTT and IRR and UTPR, this question cannot be answered in isolation from IRR and UTPR and the effect on payment, for example, of compensation. So let's go very quickly through Pillar 2. We know that the threshold is more than 700 million at the level of the global revenue of the multinational group. Effective taxation at least 50%. So the threshold for effective taxation, and we have three types of rule. Defensive rule, QDMTT, 15%. If domestic minimum tax is qualified, then there is no room to apply IRR or under taxed profit rules, UTPR. Okay, and it works basically, if not one rule, then another, going through IRR and UTPR. So IRR and UTPR is nothing else as a pressure mechanism on states to impose minimum 15%, and they are losers if they don't do it. That's how OECD sold to developing states an inclusive framework that you should have. It's good for you. Okay, so the basic logic is that tax should be paid somewhere, doesn't matter where. At the same time, BEPS was always connected with prevention of tax avoidance, harmful tax competition, and aligning taxation where there is a substance. economic substance that is relevant for, if not responsible to generate income. But if you look at this, it's completely irrelevant. It may happen incidentally, but UTPR may be activated where there is absolutely no economic substance responsible for tax, for income from which the tax is paid. And you will see that they are different, that there is very different approach by the UN and by the OECD to that conundrum, which is the interplay between investment treaties and Pillar 2. UN, in its report, here you have the specification, it's late 2023, stated that the vast majority of investment agreements are the so-called old generation, and almost 90% investments globally are protected by them vis-a-vis rules like global minimum taxation. There are 4 investment treaty protection standards that are also relevant to be invoked against Pillar 2. Fair and equitable treatment we discussed, umbrella clauses, non-discrimination and expropriation. UN continues that MNEs in scope of Pillar 2 could utilize international investment agreements as a bargaining chip to bring governments to the negotiating table. And finally, that for that even to happen, to have a productive dialogue between investors and states, most tax administrations could develop technical expertise with respect to international investment agreement disciplines through closer interaction with government departments in charge of the negotiation of IAS and the defense of ICT cases and vice versa. It's non-existent in Brazil because Brazil has no investment treaty arbitration to challenge. But of course, you have in Brazil a general attorney, and they know about investment treaties. I met some people in Cape Town. They're very knowledgeable and very, very kind and nice people. Okay, so let's continue now. How we can identify the clash between fair and equitable treatment here and QDMTT or UTPR. A case that is worth consideration is Mikula versus Romania, because in that case, Romania was required by the EU Commission to drop domestic tax holidays because EU Commission considered Romanian tax holidays as violating state aid rules. So they did it. And therefore, they prematurely revoked tax incentives to foreign investors, including the one from Sweden, Mikula. And they activated Swedish-Romanian investment treaty, against Romania because, in their view, their legitimate expectations were upset by the Romania. And the tribunal decided in favor of the investor. Although the defense of Romania was, we didn't want to do that. We were forced by European Union law. But Romania failed to transparently inform investor that there will be revocation of tax incentives without, conclusively. So investor was not well informed by the Romania about the conclusion. Okay. Now we have, and also in the context of Lone Star case that we just discussed, you can think about treaty violation. If you disagree with OECD that UTPR is non-discriminatory, and it is actually discriminatory under investment treaties, it is precluded under Article 7, Paragraph 1 and Article 9, Paragraph 1, then you may say that the violation of the global tax treaty network by UTPR is so egregious, so serious, that it violates legitimate expectations of investors globally that treaties will be applicable to their cross-border payments, which UTPR seems to ignore. UTPR is the most serious, most problematic under investment treaties and also tax treaties. It may violate various standards, not only fair and equitable treatment, but also national treatment and even expropriation. Okay, how it may lead to expropriation? Well, easily, because it applies not only to profit making but also to loss making entities. So how loss making entity can pay anything, right? Even if a loss making entity or even an entity is profit making, will be liable to pay UTPR 10 times bigger than all assets and income it has, then it will lead to indirect expropriation. And here UN says that, well, but depending now how you approach to it, will you consider that expropriation exists when one constituent entity subject to UTPR is expropriated? Or so like slicing approach, you have global group and you just slice it to that UTPR entity. Or if you look at multinational group as a whole, and only if entire multinational group is expropriated, then this threshold is met. I don't think that the latter approach will be championed. It would be just a way too much. Here I prepared for you illustration on the, I think real life scenario can be like that. Although typically Estonia is not intermediary, it may become because of investment treaty protection of Pillar 2, if you think about it. Estonia is perfect for it. Taxpayer friendly, no corporate income tax apart from upon distribution. I know that Estonia is not fan of Pillar 2 at all. So now think that US will not choose Netherlands, but Estonia to enter into different jurisdictions to have protection under Estonia-US bilateral investment treaty. And it's important because there is no member state of EU from the Western countries, the so-called old EU member states, with investment treaty that have investment treaties with US. Only Eastern European countries, Poland, Romania, Estonia, Lithuania, Czechia, they have, because of the history, because of the collapse of Berlin Wall, etc. So here you have situation that US company investing in Poland through Estonia, but even if Estonia would not be intermediary here, there is investment treaty between Poland and US. And Poland, as you may know or may not know, I assume that you may know, Poland has special economic zones. So Poland offers foreign investors zero corporate tax for a given period of time, 5, 10, 20, depending on the investment and all parameters for the exemption. Let's say that US investors started to invest in 2012 and there is exemption until 2029. And now Poland has enforced QDMTT. There is umbrella clause under this bid stating that if Poland offered something to investor, Poland is committed to respect it. So it may be violation of QDMTT, to follow to your question, okay? Under Article 2, Paragraph 6 in FINA. Why I selected umbrella clause not for an equitable treatment? Because US has policy according to which US investment treaties carve out taxation measures. Tax treaties for US are treaties that deal with taxation, not investment treaties, but there are two exceptions: expropriation and umbrella clauses. So here you don't need to have expropriation. It's enough that there is violation of the promise of Poland given to US investor in Polish special economic zone. But then, the argument of Professor Raven Avionach, for example, and also OECD, so what that US company will win arbitration against Poland under QDMTT if then another country will apply IRR? And here intermediary is in Estonia. But there is also investment treaty with Estonia. And here, if Estonia would charge tax on US intermediary entity because Poland needed to pay compensation equal to QDMTT tax to be paid, there is Article 10, Paragraph 2, subparagraph C, under US-Estonia bilateral investment treaty. Again, umbrella clause. But this umbrella clause can be activated again if there is a commitment on the side of Estonian government to promise something to US. If not, that there is no protection. Then you can say, and so what that you will win with Estonia if then UTPR will be activated? So let's say that US company have subsidiaries in Romania, and Romania will charge UTPR because Poland failed to charge irrevocably QDMTT and Estonia IRR because of investment treaty arbitration. And here you see two treaties can be applied in conjunction against the taxation under UTPR. Investment treaty between US and Romania from 1994 and tax treaty between US and Romania from 1973. And I listed only sources of law, articles, and standards of protection under investment treaty between US and Romania. Umbrella clause would be violated. It may be expropriation. Free transfer of profits could be violated. Business profits under tax treaty, related persons, and non-discrimination under tax treaty. So it's quite big. And I didn't refer before to this part with the yellowish orange background, but it's relevant to all these steps. In case Oriental Limited versus Ecuador, the tribunal applied order to order the state to stop levy tax even before the case was decided, because of the risk that continuation of taxation would destroy investment. So investor could go that far to ask a domestic court in a country which wants to apply UTPR to require the tax authorities to stop taxation because of the risk of violation of investment treaty or the risk of expropriation. Here is just the maps of the step why it makes sense to consider investment treaties when you think about Pillar 2, even though if not QDMTT, then IRR, if not IRR, then UTPR. Especially because the UTPR fate is uncertain due to the Court of Justice judgment in the end of next year or early 2027. And the G7 deal, it's good to think when you look about the global structure for Pillar 2 purposes, where do I have investment treaty protection? Not to arbitrate, but just to factor in as a discussion point with stakeholders like UN, OECD, inclusive framework, but at the end of the day, the state that has enforced Pillar 2 rules. So far, the only challenge against Pillar 2 is the one of American Free Enterprise Chamber of Commerce before the Belgian Constitutional Court due to the alleged violation of right of property under Article 1, Protocol 1st of the European Convention of Human Rights, which reflects the non-expropriation standard under investment treaties, violation of freedom of doing business and legal certainty, which reflects the core of fair and equitable treatment in respect of tax cases, violation of principle of equality and non-discrimination, which reflects the national treatment under investment treaties, and finally, the principle of legality combined with the principle of territoriality. Here is the question of customary international law. Is there a customary international law which requires certain nexus between a state and taxpayer to levy tax on the taxpayer's income? For each argument, there was a reference to preliminary ruling. Why? Because the assumption is that if the ECJ renders a judgment against UTPR, then UTPR collapses in 27 member states. And if that happens, and when, I here speculate it may be by the end of 2026, are also speculate, although under assumption that it's most likely, that the Court of Justice will ask Advocate General to render the opinion due to the complexity of the case, which may be much earlier, maybe even like spring next year. And this all will happen in parallel to the OECD discussion in the inclusion framework, right, against the US, which triggers own issues under EU treaties relative to third states. Let's assume now that the Court of Justice decides that UTPR violates EU primary law. So this is the map produced by OECD by the end of the previous year. So it may be slightly not updated, but this is the map of countries with UTPR. Okay. Not that many. If you take out Europe, you have 3 in Africa, 7 in Asia Pacific, 2 in Latin America and Caribbean, and 1 in North America, Canada. So if you take out Europe, you will end up with 12 countries with UTPR, if I count. No, 13. The less country with UTPR, the most devastating effect of UTPR as per investor. So the less proportionate it will be. And expropriation through taxation is often equated to abusive taxation measures. So let's see what will happen. Also, if you look not at the number of countries, but the number of M&Es and the money covered, if you take out US from the scope of UTPR and China, then this destructive effect of UTPR will still be massive. So what are the conclusions of this class? First of all, that investment treaty arbitration, investment treaties provides the strongest armor against the abuse of states' power among all legislation in the world, like no doubt about it. And also, the abuse of states' power to tax is not unusual, actually. It happens. And because it was identified by tribunals, maybe not always everything what they said was correct, but it upset countries and they don't want arbitration tribunals to deal with the fact that they abuse taxation from time to time. Fair and equitable treatment is the most powerful standard, most capacious, will be applicable in most cases. And among the emerging developments, one of them, Pillar 2, Pillar 2 is really problematic, and let's see what will happen in the context of investment treaty protection. What is clear is that there is certainly not enough dialogue between investment treaty experts and tax experts, both on the level of the private actors like we are here, academics like we are here, and states. So I'm very happy and honored that you gave me floor to talk a bit more about it, and maybe I spark interest, at least a little interest in some of you, and you will be reading some stuff on it. Thank you.
There's a few comments I would like to make to bring into perspective, since there's a lot of classes here on tax treaties, and we've heard Blazej mention, for instance, how the UN was trying to reconcile its recommendation for a broader carve-out, or interpret that the scope would only be materializing if it was expropriation at the ultimate multinational group level. So there's all these different messages around investment treaties. As there are different messages, as there are also different messages with respect to tax treaties from different stakeholders in international governance. So for instance, and it's important for the group here that studies tax treaties so much to have this perspective as well. Entities such as the IMF and the World Bank that have played significantly in resource mobilization and capacity building in developing countries, they developed a view over time, a published view, this is not innuendo, a published view that tax treaties themselves, and there's one article by one of the former heads of the tax policy unit at the World Bank that called them, it's a leaky tub. There's revenue leaking from developing countries because tax treaties are overly protective of investors, overly protective of the residents country, overly, let's say, detrimental to the source state. We do have friends that write about the fiscal imperialism through tax treaties, and all of that is brewing in the background. When you look at that, and at the same time, you have a lot of developing countries that, in order to attract tangible asset investment, right? Since they're not in the market to compete for human capital, what do they offer? Not only to their alternative extracting industries, they also offer platforms for logistics, distribution, etc. So they have special economic zones in a lot of different places. They have free ports. So they have all kinds of setups where geographically you end up with a tax holiday. And this is looked at from a great perspective unfavorably by such entities such as the IMF and the World Bank, as perhaps it's an even inefficient tax incentive. Perhaps it's a waste of resources, perhaps a waste of fiscal budget for a country that is borrowing from the IMF or borrowing from the World Bank. So there's a much bigger group of stakeholders at play and issues that may or may not have merit, but that are in the background, and very strongly so. So when at the same time you have another body of international law, which is even more protective of international investment, it really creates a lot of distrust. And then this distrust taints the discussion. It contaminates the discussion. It makes, for instance, the OECD state that there is absolutely no issue with UTPR under treaty law, when it's a consensus, I would say, academically at least, that there are many, as Blazej has mentioned here. So the point I wanted to highlight to the class and to the students here at our dear IBDT is take all the statements you get on both networks of international law with a grain of salt and skepticism. Because aside from all the technical discussions that we're having here, that all the learning that you do here, there's a lot of very serious politics that brings serious consequences that can shape the rules. So this is just the point I wanted to highlight, because as you study this topic, I hope also that it has sparked the interest of many students here. But as you study the topic, you're going to find contradictory views. You're going to find a lot of very official, very formal, and lengthy works, in a way criticizing, being critical of these instruments, or being skeptical about arbitration panels, being skeptical about the honesty of arbitrators. So this is actually official, it's public, it's out there. And it's a war of narratives that our field of international tax is a part of. We're not insulated from it. As the world of trade and tariffs is not insulated from narratives, the world of tax is also not insulated from tariffs. So this is just the additional add-on, so that if anybody starts researching, started getting mixed messages, don't get confused. Try to separate the technical stuff from the politics.
Thank you, Romero, for contributing to this panel, and a warm thanks to Blazej. Once again, I think the objective was achieved in terms of spreading the word and bringing a highly sophisticated class on bilateral investment treaties. I think I could not think of anyone else more apt to deliver this class as you, my friend. I have been following your work on this area, and I think this is a highly important topic for Brazil. We are being pushed. We've been living in a closed economy world in the past, but we are in the verge of changing. Brazil sometimes is pushed into signing these kinds of treaties, and now we are also discussing. We are worried with foreign direct investment. Of course, we now changed our, let's say, the low tax jurisdiction regulations to say that you can remove the low tax jurisdiction label for countries that do invest a lot into Brazil. This is a sort of a no topic for Brazilians because we don't have many bilateral investment treaties. That could be one idea that, or one justification why we have not been studying this so much in Brazil. But it is, though, very important for Brazilian companies investing abroad. Normally, we have been doing treaty shopping for tax reasons, but this is a very important and serious treaty shopping that can and must be done when Brazilian multinationals invest abroad. Many multinationals are already aware of that, but it's not common sense. It's not available for everyone doing business abroad. So I do hope that this class will really lit up a spark in students, or people hearing us or watching this class later on. This is a very important topic. We need to develop more content on that. As someone that, and you as well, working here at IBDT, it's our role as well to create more opportunities like this and improve our presence in this topic. Thank you again. This has been terrific. Thank you, Blazej. Vamos.